Yeah. Yeah, unless properties are really aggressively priced, it is slow. So how that's addressed with sellers, that's a good question. You know, if they're probably reading the newspaper just like all of us do, and they're saying that the whole market has slowed, as a matter of fact, until there's resolution with the tariffs and so forth. Today's a good day in the stock market, right? So there's something good, right? Finally, right? I'm tired of losing money every single day of my life. Jerry, you're laughing. It's painful. I know you're invested too. So
there's no point looking on a day-to-day basis. They'll all turn around tomorrow.
You know, I don't disagree with you, Jonathan. I don't have the resolution you have. So.
That's because I don't have the investments here.
That's the problem.
It's a bad day at the house.
You know, that's what actually I don't gamble. I can't go to Las Vegas. I don't gamble. It just bothers me to spend $1 and not get anything out of it. But
the stock market is gambling.
Yeah.
Okay, thanks, Carlos. Appreciate that. Just throw it out there, all right?
Yeah, so I think that because there's probably a lot of disillusioned sellers wondering why they're not getting more and more and more for the sale of their property. I think that's what everybody's becoming accustomed to. And supposedly, year over year, the average selling price or median selling price in Orange County is up 5%, but the number of transactions is at the lowest since 2009. That's low. So if people want to sell their homes, maybe I can help provide you information, documentation to convince them to give consideration to lowering their prices. But anyways, that's not the purpose of today's discussion, but it's interesting for all of us to hear what's taking place out there. So we see exactly what's going on. And we've had a number of cancellations simply because people are concerned. They're watching their portfolios devalue and they're backing out because of fear. But that's always the best time to buy, right? Right? You're buying stocks when everyone else is fearful, buying real estate when everyone else is fearful. And nothing is changing in terms of California with the cost of construction. So that is not going to change, so at least for a long time. You think about what's taking place in the Palisades. There's such a demand for materials. The cost of materials is just going up. And of course, with the tariffs, it's just going to go up. It's going to continue to drive prices higher. But if they need to sell now. So today I want to talk about the Tenant Protection Act. It's something we have discussed in the past, but also before we begin that, there's a few new changes that have taken place. And of course, it's always overwhelming. But Assembly Bill 2801. And this is effective July 1st, but actually it's taking effect April 1st. So now, if you're a landlord, you must have, effective April 1st, for any move-outs that take place April 1st or subsequent to that, you must have pictures of the areas in which repairs are going to take place. In addition to that, you must have pictures of those areas subsequent to any repairs taking place. There's an exception if the repairs are $125 or less. Photographs are not required, but it's kind of a rarity that it's only $125 or less. So what takes place? Right now, if it's a move out scheduled for April 1st or later, before they move out and before repairs, there must be photographs from those areas that are damaged or where there are deficiencies. Once it's done, you must take pictures. Not only that, but when somebody is vacating a property, you have 21 days subsequent to vacating the property to provide the tenant with an accounting of any deductions from the deposit, if any. Provide them with a balance of the refund if there is a refund. And now you must also provide them with the pictures that you took before and after the repairs. So if you don't take photos, then you are not going to be entitled as a landlord to recover any costs out of the security deposit for the repairs that are required. So you're going to be relinquishing that right. So big change there. It's a lot more work. And then effective July 1st, at the initiation of a tenancy, you're required to take photographs of the units. And then once again, adding to that photographs of the unit before the tenant vacates the property. And then once they vacate the property and you've completed the repairs, pictures of the property thereafter. Without those photographs, you're going to relinquish your rights to recover any money out of the security deposit for any damage that the tenant has caused.
Will pictures that you enter into the MLS as a listing agent suffice?
I would say no. Well, the point is, you need to provide those to the tenant directly. So that's the issue. Now, how we get around doing all that, that's going to be a good question, how it actually happens. Can you take a video? Possibly. The statute doesn't state video, but maybe that would be acceptable. So that's a possibility. So we have a lot more work to do in that regard. And then, let's see. So and then the other aspect that I just want to mention when talking about providing a notice or a complete accounting to the tenant within 21 days of the date that they vacate the property. If you don't do that, and I think the question also comes up in many cases, well, they moved out. I don't know what the actual cost of repairs are going to be. You're entitled to estimate what those costs of repairs will be. And with that estimate, send out the notification to them in regards to the deductions, send the photographs. And then once you have a resolution in regards to what the actual cost is, unfortunately, you're going to have to be providing documentation as to the invoices, so on and so forth, to validate the costs or deductions that you actually took from the security deposit. Any questions about that? So it's simple. Pictures now, before they leave, pictures after they leave, July 1st, pictures before they move in, pictures before they leave, and pictures, once again, after any deficiencies are corrected. Together with providing an analysis of any deductions made within 21 days of them vacating the property. Then also, let's assume you haven't used up the entire deposit, you're required to issue a balance or a refund of their security deposit. If you don't do all of that within 21 days, the property owner could be subject to damages of 3 times the security deposit. So it's pretty substantial.
So you're gonna have to have a contractor that can do it within those 21 days.
You don't have to have it done in 21 days. You just need to have an estimate. And an estimate could include any vacancy also. Let's assume they moved out or they stopped paying. It's just an estimate. You don't have to have the work done within that 21 days. That's why you just need to provide an estimate of any deductions.
But you're supposed to have their deposit back after the 21 days, right?
Assuming there is anything remaining in their deposit. But if I have $3,000, I know certain repairs are going to cost me $2,000. Maybe they've defaulted on the lease. I can estimate the number of days for vacancy. I may have to estimate the cost for carpet replacement or damage to the property.
And what's the time frame after that? Like if
As soon as it's done.
okay.
So obviously something reasonable, 30 days probably, but there's nothing specifically in the statute that dictates what the time frame is in which you must provide them with the actual documentation of those invoices. But they'll be angry about that, and I'll remind you. And obviously you want to get it back in the market, so you want to get this thing corrected. And then the other aspect that's been a question is Assembly Bill 2747, notification of positive credit. So it's a law focused on tenancy and credit reporting, specifically mandating that certain landlords and property managers offer tenants the option to have their on-time rent payments reported to credit bureaus, which can help build their credit score. Now, what's very interesting about that, did you notice I said they have the option to have their on-time payments reported? They also have the option to have their delinquency payments reported.
So how can you do it?
How can you do that? Well, that's a good question. Fortunately, there's exemptions for most of the people that we probably work with. So I'll talk about those exemptions first. So, and this is going to apply to residential rental properties with 16 or more units on a single parcel. I don't think we have anybody in this office, that we're representing that has a building with 16 or more units, but it's very possible that that could happen. So if they fall into that category, they're going to have to give the tenant the option of positive credit reporting to the bureaus. So how we do that exactly, I'm not 100% sure how we're going to submit that information to the credit reporting bureau, but it's probably going to be no different than a credit card is, or a mortgage lender, as a matter of fact, or a servicer. And then, in addition to that, the other applicability to this guideline, so properties with 15 or fewer units, if the owner is a corporation, real estate investment trust, or an LLC with at least one corporate member, or that entity owns more than one residential rental property. So let's just break that down. So real estate investment trust, there's no exemption. If it's a corporation, an S corp. Now this is a reason for people when they think about owning property, investing it in a corporation or S corp, to not do that. An LLC is going to be probably a better choice for them. If it's an LLC that owns a property, or the property is vested in an LLC, there are various members that own that LLC. If one of those members is a corporation, the exemption is not available to them, and they're going to have to offer the tenant the opportunity for positive credit reporting. And it's so simple. Any entity that owns more than one residential unit may have the obligation for positive credit reporting. They may. The exemption would be if I own that property and I own an LLC, and none of the members of the LLC is a corporation, I do not have to comply with the law. I'm exempt from it. But if I have an LLC and I have other members in which one of those members is a corporation, then that entity, the LLC, will have to comply with the positive credit reporting. If that property is owned by a real estate investment trust, even though it's two properties, they have to comply with offering that opportunity to the tenant. If it's a corporation or S corporation, there is no exemption for them. They have to offer the opportunity for positive credit reporting. So how do most people take their properties? They probably have invested in their individual names, so they would be exempt. In addition to that, if they have an LLC and none of the members are a corporation, it's just they took out an LLC. It could be a single member LLC or an LLC which myself and my neighbor are partners. As long as neither one of us take it, or one of the members is not a corporation, we have an exemption to the reporting requirements, or giving the opportunity to the tenant for positive credit reporting. So I want to make sure that everybody understands that if there's any questions about that. And now, when does that apply? If I'm not exempt, I had to have made that offer to the tenant before April 1st of this year. So if I own a building that's 16 units or more, I would have had to have made that availability of the positive credit reporting to them before April 1st. If I am an LLC and one of the members is an individual and one of the members is a corporation, if I have more than one residential property, I would have had to have made that opportunity to them for positive credit reporting by April 1st. Now, in the current lease agreement, the RLMM, you'll see that the offer of tenant positive rental payment reporting is now a part of the packet. We have all these different forms that are included in a residential lease agreement. So even though if I'm exempt, I don't have the obligation to make the offer to the tenant. Let's assume I'm just an individual and I own one residential property that I'm leasing out. I have no obligation to make that offer to my tenant. In the new residential lease or month-to-month residential lease agreement, this document is included, even though it's not required by law. If you have a property owner that owns just one rental property, even if it's two, and if it's an individual, Richard Moore, we're going to check this box, notice of exemption. We're just gonna provide it to them. So the details of what I talked about is included in this form, as a matter of fact. Let's see. So if I look at section 1B of the form, it says housing providers shall comply with the tenant's request for positive rental payment information, reporting to a nationwide reporting agency in either of the following two scenarios. The property in which the premises is located contains 16 or more residential units. So a building of 16 or more, I'm not exempt. The property in which the premises is located contains 15 or fewer residential units, and both of the following apply. The housing provider owns no more than one residential rental property, regardless of the number of units, and housing provider is a real estate investment trust, a corporation, or limited liability company in which at least one member is a corporation. So these are the entities that are not exempt from the positive credit reporting. In the event somebody is not exempt, you're entitled to charge them $10 a month. The tenant can actually opt out, and if they opt out no sooner than 6 months after opting out, they can then request, assuming that the property owner is not exempt, they can request to have the positive credit reporting.
What about the under the trust?
A trust would be exempt. It would. Your family trust, right? Then your trust would be exempt from it. And let's assume that your trust, you have somebody that you partner with and you created an LLC, and it's your family trust that is one of the members, it would still, that LLC would be exempt. But if you had an S corporation, that was you on the S corporation, they're a shareholder, and it was a member of the LLC, then no longer would that LLC be exempt. The LLC would be required to offer that opportunity for positive credit reporting. So if it's your own family trust, that's a member of the LLC, and that's the owner, that's the member, then it would be exempt. But if it's just someone's family trust, the exemption applies to them. So you don't have to offer that. And we would just complete the form accordingly. Just going to check the box under section 1C. And that's going to be how we're going to proceed. So when you're working with a property owner, when you're leasing a property out, you need to ask them those questions. Or you need to look at the vesting. That's really what we should do. A lot of times people don't even understand how their property is vested. So if you see that it's vested in an LLC, the question you should be asking, well, who are the members of the LLC? If a member is an S corp or a corporation, they are not going to be exempt. They will have to give the opportunity to the tenant to provide positive credit reporting. If all the members of the LLC are individuals, the exemption exists, so that you don't have to make the offer of positive credit reporting. Now, if there's anyone has any questions about that to confirm, what's taking place, this is a good opportunity to be sure that we're all understanding of that. That's going to affect all of us. Leasing is just getting so complicated. Everything that's required of us.
I don't see how they're gonna even be able to police
I don't know how they're going to police it either. You know what's going to happen. Someone's just going to figure it out, right, and make a complaint, and that's really what's going to happen. They're going to file something with the housing authority.
Or an attorney's gonna figure out how to.
Mm-hmm. They're going to be soliciting
action
people to
lawsuit.
try to start some kind of litigation or get money for these individuals, right? That's really what's going to be happening. And the people that maybe, it's interesting. We've had people in the past that have questioned termination of tenancies based upon rent cap and just cause. So they have some idea in regards to what's going on. If they don't want to move out, or that the landlord's trying to terminate the tenancy, suddenly they have some knowledge and they're trying to enforce these different guidelines against the landlord. So
where they have to report it, and then
yeah, actually on the form itself, it's going to give them an option to choose one of the 3 credit reporting bureaus. So they can make a choice if the landlord's not exempt in regards to which one they want it reported to.
So it's tenant has choose and then landlord.
will have to comply with that if the landlord is not exempt, correct? So on the form that we have on the screen, let me see, where is the section in there talking about which credit reporting agency? Section 5. If tenant elects positive rental information reporting, housing provider will provide the information to the following consumer reporting agencies. So they can check one of those, TransUnion, Equifax, or Experian. And then it's a monthly fee that can be charged of $10.
Each borough has monthly of $10 or.
The landlord can assess a charge of $10 for the monthly reporting requirement. If the tenant chooses to have it reported. But remember, if the landlord is exempt, there's no obligation to do that. I would say most of the people that we probably work with probably are entitled to the exemption and don't have the obligation to report it to these credit bureaus.
My question is, how do you can pick the two borough, the credit company, and then the landlord charges $20 per month?
We're going to give them the option of one. That's my understanding of the statute, but they have the choice of one credit reporting bureau that they can have it reported to. I'll have to confirm that just to be sure. But I'll make sure of that in regards to what it was my understanding it was just one, but you're right. If they charge, I would assume that if they choose all three, that the landlord probably cannot charge more than $10 in total.
It gives them the option, it says agency and an IES parentheses.
Yeah,
Agency.
so it sounds like it's giving them the opportunity to choose all of them, as a matter of fact. But I'll confirm that. And I think even more importantly, how we actually report it to a credit reporting bureau is going to be the most difficulty, as a matter of fact, to having this form completed. What must the landlord do to do that on a monthly basis? Okay, any other questions about that? Yeah, there's always questions, right? Unfortunately.
Only from the people that aren't here.
Yeah. So something else I wanted to review once again, because there are always questions, is the statewide rent cap and just cause eviction law. If you're not exempt from the statewide rent cap and just cause eviction law, that's exactly what we're going to be talking about today. So if you're exempt, there's no limitation in regards to what you can charge for rental increases. There's a methodology. So for example, if you are subject to the rent cap and just cause eviction law, today you can't increase rents by more than 8.9% during a span of 12 months, and nor can you increase rents more than twice in a 12-month time frame. However, if you're exempt from that law, you can increase the rents to any extent you want in regards to a percentage increase, but the notice period is going to be affecting you. So let's just, and keep in mind, what are the notice periods for rents that are 10% or less, or an increase of 10% or less, or an increase of more than 10%? Anybody tell me that? I always hated that when I was in school. There's always somebody that knew the answer. It wasn't always me. It's not that funny, Jonathan. So he's not. All right. So the question is, what is the notice period for a rent increase of 10% or less? And that's a 30-day notice. And if you're subject to the rent cap and just cause law, you can't increase rents more than 10%, but you're also limited to a 5% plus CPI increase or index. And today, right now, that's 3.9%.
Does that change if you've been in?
It changes every
living in
year.
a unit for more than a year?
It doesn't, no, it doesn't change if you've been in the unit for more than a year, but let's assume you're subject to the rent cap and just cause eviction law. So the rent cap, you cannot increase the rents today more than 8.9% over a 12-month time frame, and nor can you have more than 2 rent increases during that 12-month time frame. If you're not subject to the law, you can increase rent as often as you like, but it's going to be the notice period. So let's assume cumulatively, if I'm not subject to the rent cap aspects of it, I can increase my rents as much as I want. But I've increased my rents once at 5%. Remember, this is going to be over the lowest base rental during that last 12-month time frame. And I want to increase my rents again within 3 months thereafter, and it's still within that 12-month time frame. If the total cumulative rent increase over the duration of 12 months exceeds 10%, now I'm going to have to give a 90-day notice for that second increase. So typically, we just think 10% or less, 30-day notice. More than 10%, it's a 90-day notice to increase rents. Now, what takes place if we have a long-term lease? Well, if we have a lease for 1 year, let's call that long-term. Theoretically, we should be giving a 90-day notice if we're going to increase the rents on that lease by more than 10%. So if it expires July 1st, we should. Into July. Okay, so April 1st, we should be giving notification to the tenant that we're going to be increasing the rents by more than 10%.
That's assuming you're not in a rent control city.
Yeah, rent control, if it's in Los Angeles, I think for properties built before 1979, you're limited to what, a 4% increase? Oh, 3? Okay, so it's even worse than I thought.
San Francisco, 1%.
And 1%. So anything that's more restrictive will supersede the Tenant Protection Act. So there's a couple of different names for what we're talking about. And thank you, Steve. The Tenant Protection Act also is known as AB 1482, and it's also known as the Rent Cap and Just Cause Law. So 3 different terms to describe the same thing, as a matter of fact. So exemptions from rent cap and just cause. Let's define. Rent cap is just how much I can increase my rents over a duration of time, and just cause is referring to evicting a tenant or termination of a tenancy. And there are 5 different aspects they're the same, and there are some differences. But exemptions from rent cap and just cause, single-family properties and condos are exempt if you provide the notice of exemption. Can you pull up the RCJC?
Yeah.
All right. Now, most of you know this. As a matter of fact, show me where the box is. All right. I think it's up a little bit farther. This is just so critical on this form, the RCJC form. If someone is exempt, we need to check the box in terms of the exemption. Otherwise, we are now subject to the law. So I guess the way to look at it, everyone in California is subject to the rent cap and just cause law. You can take advantage of the exemption, assuming you're entitled to the exemption, but everybody is subjected to it. So single family properties and condos are exempted if you provide the exemption and the owner is not a real estate investment trust, a corporation, or an LLC in which at least one member is a corporation. You see what's taking place here? There is some conformity in regards to what we're talking about as to entities that are exempt from the positive credit reporting. So once again, if it's an entity that is a real estate investment trust, a corporation, or an LLC, in which one member is a corporation, you're not entitled to the exemption. That means I'm subject to a limitation today of 8.9% for a rent increase. And if I'm going to terminate a tenancy, I have to use one of 15 specified reasons to terminate a tenancy. As a matter of fact, I may not even be able to terminate a tenancy if there's no violation. Now, there's still another exemption. You can be exempt if the property is 15 years of age or newer, and that's based upon when a certificate of occupancy was filed. If it's a duplex, duplexes there may be exemption available for a duplex. Assuming I'm the owner of the duplex, I move in before the tenant moves in, and I continue occupying the property, I can be exempt from the Tenant Protection Act. But if I move in after one of the tenants, then the exemption is not available to me. So what about triplexes, fourplexes? The exemption is not available unless it's a building who had a certificate of occupancy issued during the last 15 years. Dormitories isn't that interesting. They're not subject to rent cap or just cause eviction. And then also, and this is becoming more and more prominent, owner-occupied single-family properties renting no more than 2 bedrooms, including accessory dwelling units. And there are a lot more ADUs that are being constructed. So if I'm occupying the property and I have more than 2 bedrooms rented out, then I am not entitled to the exemption for how much I increase rents. And in addition to that, when I may terminate one of the tenancies. Any questions about that? So remember, this does not apply to commercial property. Vacation rentals, in a sense, are exempted. You know, the vacation rentals of 30 days or less, they don't fall into the category. The application of rent cap and just cause applies to properties that have been occupied for more than 12 months. So you can see why vacation rentals probably don't apply, as a matter of fact, or why they're exempted from it. And supposedly this law will sunset or expire January 1st of 2030. So what do we need to do when we're completing a lease? Now, this went into effect in 2020, and I know everyone's saying, well, why are we talking about this? This is 5 years into the law itself. Well, I do see leases that have been signed in the past, and we have had long-term tenancies, and maybe the lease was never extended. However, they've been living there in a month-to-month tenancy. So if the landlord has not provided them with a rent cap or just cause notice, the landlord, unfortunately, is subject to the limitations in regards to rent increases and how they can terminate a tenancy. So that can be very critical. And in the event you're renewing or assisting somebody with renewing a lease, you should be evaluating the prior documentation to understand whether or not the tenant was ever served with an exemption notice. Not only that, but once a lease becomes so old, the guidelines or laws have changed so dramatically. If it's more than a year old and they want to renew a year-old lease, it's probably okay just to extend it. If it's 3 years or older, I probably would suggest drafting a new lease, but unfortunately, you're going to be faced with all the same disclosures, or not the same disclosures, but all the additional disclosures that have been added when creating a lease agreement.
So Richard, this is something you advise your client?
Yes, absolutely. Because they are not going to know. They're not going to know about the positive credit reporting. They're not going to know about how much they can increase their rents. They're not going to know whether or not they can terminate a tenancy and be in violation. Because if they don't comply, let's assume they're not exempt. They never signed or completed the exemption, and they're terminating a tenancy. They very well could be violating the law. And not worst case would be if they try to terminate a tenancy and they don't have the exemption available to them, then the termination of tenancy is not going to be valid. So that's going to be a real surprise for them. So what if a tenant's on a month-to-month tenancy? What can you do? Let's assume they moved into the property before 2020, and that's probably not uncommon. You can actually serve them with the rent cap and just cause notification. But how would you do that? You need to attach that to a or a change in terms of tenancy. So California law, if it's a month-to-month tenancy, allows us to serve notification to a tenant. And we can attach that, and we can do that, for example, to increase rents. And once 30 days have lapsed upon delivery, the rent increase becomes valid. And if we are on a month-to-month tenancy, we can attach this form to the change in terms of tenancy. Could you move the form up?
Is it right here?
There it is, thank you. If you can see where the cursor is right there. So there's two things. Let's assume a tenant's on a month-to-month tenancy and we never did give them the exemption notice. And now we realize that we need to do that. We can actually just, the tenant and the landlord can agree to sign the change in terms of tenancy. Unfortunately, it must be signed by hand. It can't be signed electronically. Odd. If I'm creating a new lease and the RCJC is attached and I've got the exemption form included, it can be signed electronically. But if I'm changing, if it's another change in terms of tenancy, so that could also include a rent increase, it must be signed in hand and there must be a specific form of delivery and that cannot be electronic. Otherwise, it's not going to be effective. But if the tenant refuses to sign, and I witnessed that also, or tenant refuses to sign the RCJC because they're nervous about it. Once you deliver this, the change in terms of tenancy together with the attached RCJC, then it becomes effective 30 days later. Now, what happens? Yeah, you're gonna say something? Oh, no, go ahead.
If we deliver it, take any actions on it, how do we know?
There's nothing to do, right? So you post and mail, something like that, and that's deemed to be valid delivery.
That's it.
Yeah, interestingly enough. You can mail it. They're given an additional 5 days, besides 30-day time frame for it to become effective.
Well, we should have some sort of confirmation that we received it, right?
That's the ideal situation, knock on the door and hand it to them, right? But are they going to sign anything if they have refused to sign it to begin with? That's a good question. You can also hire a process server. It's probably $165 to have somebody just deliver it. So you've got a third party that's completing the form. So it's independent, but I know Sarah and Jay have done this before. They've delivered documents directly to people's homes.
Probably requires mail, which requires a signature would be.
Well, they don't have to sign. That's the interesting thing about a notice of change in terms of tenancy. Let's assume you're just increasing the rents.
Yeah.
They don't have to sign. There's no obligation for them to sign. It's just delivery and the type of service.
What about the tenants who live in month to month and then they have the exemption RCJC? Then when landlord wants to increase their rental payment, does it give them the email notice is good enough or they have to send it with this form?
If it's a month-to-month tenancy,
They already have RCJC.
okay, you have the RCJC, you would use the notice of change in terms of tenancy form CTT. Can you pull that up, Carlos?
Where is it?
Did I bring it? Did I give it to you?
No,
Yeah, I did.
this is it here, actually.
Okay,
I have it.
So if we're going to increase the rents, it's a month-to-month tenancy, the landlord must sign it. Can't be assigned electronically, nor can it be delivered electronically. Delivered to them, handed to them, post and mail, then it becomes effective 30 days following delivery. So if it's a notice of change in terms of tenancy, so it's a month-to-month tenancy, we're going to increase the rent. Complete this form, and the landlord must hand sign the form. It cannot be signed electronically, nor can it be delivered electronically. If you're signing a new lease, then it's acceptable for the landlord and the tenant to sign all of the forms, the lease agreement, the RCJC together. So that's acceptable on a new lease agreement. But a notice of change in terms of tenancy with the landlord is just unilaterally changing the terms of the lease agreement. They must sign personally.
What if you're just renewing?
I'm sorry, what?
What if it's just a renewal, like they've been there for years, but
No. Then that would be fine. They can still be signed electronically.
and just one of these, or do you have to do the whole?
Well, if you're doing a renewal, you could just use an addendum as a matter of fact, or, and you would attach, if they never signed an RCJC in the past, you would attach that to the form. That would be acceptable. What happens if a tenant, the lease is expiring, and they're refusing to sign a new lease agreement. And the let's assume if the landlord is exempt, the landlord doesn't have to renew anything. So the landlord has so many options if they're not exempt, if they are exempt from the Tenant Protection Act. But if they're not exempt, their options are limited. But let's assume a lease is coming up and I'm offering them, and I want a new lease signed, and I never had the rent cap and just cause notice signed previously. Well, if the tenant refuses to sign that, there's two things that the landlord can do. They can just evict them. They can say, I'm not going to renew it if it's being renewed based upon similar terms, so on and so forth. Or they can allow the lease to expire and they can accept the next payment and becomes a month-to-month tenancy. And then they can actually then serve the tenant with the notice of change of terms, of tenancy, form CTT, and attach that the rent cap and just cause notification. So they can then imply that or invoke that over the tenant. Any questions about that? Is it clear? If it's not clear, this is the time we should be asking those questions, as a matter of fact. And then,
Richard,
yes,
I have a question. The lease agreement can be signed electronically now, right? Or
yes,
no?
it can. Yes, it can.
Okay, okay. Thank you.
But the notice of change in terms of tenancy, which is signed by the landlord and it doesn't require the tenant's signature, cannot be signed electronically.
Yes, okay. Thank you.
And then currently, if the landlord is subject to the Tenant Protection Act, meaning they're not exempt, we can increase rents by 5% plus the cost of the CPI index. So currently, and the way it works, unfortunately, if I'm going to increase rents August 1st of this year or thereafter, I can use the 5% plus the current CPI index as of April of this year. If I'm increasing rents before August 1st of this year, I have to use the 5% plus CPI index for issued the prior April. And it just so happens, April of last year is 5% plus 3.8%. So 8.8 this year, it will be 8.9%. Are you happy it came today, Bill? And then what if I don't increase my, I have never increased my rent on a tenant over the last year. Can I bank that rent increase? No, you can't. Once again, if I'm not exempt, it's limited to the maximum, in this case, it will be 8.9% over the last 12 months. If I'm exempt from the Tenant Protection Act, I can increase the rents by as much as I want, but you're still limited to a 30-day notice for rent increases of 10% or less. More than 10%, it is a 90-day notice, and it's cumulative over the 12-month duration of time. So you have to keep that in mind. And then vacancy decontrol. Let's assume the tenant moves out. Am I limited to how much I can increase the rents? No, there's no limitation there, as a matter of fact. And then tenants cannot waive their rights in regards to the rent cap and just cause, as a matter of fact. No matter what they say, it's voided against public policy. And then let's see. Just looking for some more pertinent information here. So what are the reasons? ADUs, that's something that is now becoming much more prominent. So does a single family property with a detached grandmother unit qualify the duplex exemption? So it does not, but it will only if the owner in a duplex occupies the property before a tenant occupies the secondary unit. But ADUs are not automatically exempt from that, as a matter of fact. So in terms of the exemptions for an ADU built during the last 15 years, they're exempt from the Tenant Protection Act, meaning I can increase the rent or I can terminate a tenancy without cause. But once that 15-year time frame lapses, they're now subject to the Tenant Protection Act, meaning I'm going to be limited to the rent increase. In addition to that, I'm going to be limited to the number of reasons I can evict a tenant for. If I'm exempt from the Tenant Protection Act, I don't have to give a reason when terminating a tenancy. I just have to give appropriate notice. So if a tenancy is 12 months or less and I'm subject to the Tenant Protection Act, do I have to give, or what is the notice period? It's only 30 days. But if the tenant has occupied the property for more than 30 days, I have to use one of 15 reasons for terminating that tenancy. And then owner occupied property. So if the property is a single family home where the owner lives on site and rents no more than 2 units or bedrooms, including ADUs, both the ADU and the main home are exempt from the Tenant Protection Act, just cause eviction requirements, but not the rent cap. So that means I have a home and I have an ADU and I'm renting out 2 units or 2 bedrooms out of the entire property. I will be subject to how much I can increase the rents. And my example would be 8.9%, but I may not be subject to the reasons for termination of those tenancies. And something Steve brought up before. So if local laws are more restrictive, that will supersede the Tenant Protection Act. And the reasons for termination of a tenancy, let's go over there. So if I am not exempt from the Tenant Protection Act, if I want to terminate a tenancy, there are 15 reasons that I must cite, or one of 15 reasons I must cite. 4 are at fault and 11 are, some are at fault and others are no fault. Non-payment of rent is at fault, a breach of a material term of the lease, for example. If they've done something and I've given them notice to correct the violation, a nuisance. Using the property for unlawful purposes, maybe they're cooking drugs in there. Criminal activity, refusal to allow entry to the landlord to the property. Waste, meaning they're damaging the property. Assigning or subletting the property is a violation. Or actually, if the tenant gave notice that they're moving out and they didn't move out, that's a reason to terminate the tenancy. And then there are those times in which a company provides housing. And once they're terminated, then that is a reason for terminating the occupancy. And then let's see, when the tenant fails to vacate, once again, after providing the owner with their own termination notice. So no fault reasons, owner occupancy. So if I am involved in a month-to-month tenancy and a family member of mine is going to move into the property, that is a valid reason for me to terminate the tenancy. However, the property owner is going to be required to pay 1 month's relocation assistance, and that's done in 2 ways. You can write a check, or you notify them in advance that I am going to, you won't be charged rent for the very last month. And if you don't do that, then the termination of tenancy is no longer valid. So it continues. So if you're going to withdraw from the rental market, substantial remodeling, compliance with the government order to vacate the property. So a couple of things in regards to people that believe they're going to lie and say that my daughter's going to move into the property. Well, the law has tightened up in favor of the tenant, as a matter of fact. So with that said, if I'm saying my daughter's going to move in, then I must do certain things. I have to identify in the written eviction, notice the name of the relationship to the owner of the intended occupant and include notification that the tenant may request proof that the intended occupant is actually an owner or related owner. So if I'm having my daughter move in, that's my reason for terminating the tenancy. Assuming I'm subject to the Tenant Protection Act, they can ask for proof that that's my daughter. You have to give it to them, right? But I also have to give them notice that they're entitled to that information. And then somebody has to move in within 90 days after the tenant has vacated the property. And then in the event my daughter doesn't move in, then I have to offer the unit back to the tenant. It's crazy. The terms that were provided to them previously. And then if the tenant doesn't move back in, then I have to offer the property on the market at the same rental rate I was charging the tenant who I evicted. So you can see how important that exemption box is. Would you pull that up again? We don't have to go through that.
So how long the guard has to stay there?
A year, a long time, huh? And then another reason to evict a tenant, if I'm subject to the Tenant Protection Act, meaning the exemption is not available to me, or I didn't take advantage of the exemption, is substantially remodeling the property. So I have to give them written notice. And it also indicates that the property will not be habitable for at least 30 days. In addition to that, I have to provide them copies of permits, so on and so forth. Yeah. And then if the tenant is interested in reoccupying the rental property following the substantial remodel, the tenant must inform the owner and they may have the opportunity to reoccupy the property. So we have to be very careful for the reasons if we are not exempt from the Tenant Protection Act when terminating a tenancy. Likewise, we have to keep track of any rent increases when determining what the notice period is, whether it's 30 or 90 days based upon the rent increase. So remember, at 10% or less over a 12-month period, that would require a 30-day notice. And remember, it's cumulative. Anything more than 10% over a 12-month period is going to require a 90-day notice, whether you're subject to the Tenant Protection Act or not. Well, actually, if you're subject to the Tenant Protection Act, you can't increase rents more than 10% over a 10-month period. That's the max, and right now we're limited to 8.9%. What are we seeing in terms of rent increases now? Anybody? Nobody wants to tell me? What percentage though? Well, it's $200 or $300. You know, what's rents? What are rents in Orange County? 3,000 to 4,000. So that's below the cap. Even if you go to an Irvine company property, if the building is less than 15 years of age, they are not subject to the Tenant Protection Act, assuming they provide the notice. So keep that in mind. So that's what I have for today. Any questions about, I think the most important thing today, well, there's a lot of things, but Assembly Bill 2801 in regards to photos of the property when a tenant's vacating. So remember, as of today through July 1st, photos before they vacate, before any repairs, photos after repairs are completed. And then otherwise, if you don't do that, when making the deduction, you're not entitled to take any deduction from the security deposit beginning July 1st before the tenancy begins, taking pictures of the interior of the property before they occupy, and then pictures at the time they vacate before repairs and pictures after the vacate. And those must all be provided to the tenant in the event you're going to make a deduction from their security deposit.
Along with receipts, right?
Along with receipts, you need to document exactly what's going on, exactly. And then just to reiterate, Assembly Bill 2747 regards to the notification of positive credit. It applies to residential rental properties with 16 or more units in a single parcel. So there are no exemptions for that. It also applies to an owner who is a corporation, real estate investment trust, or an LLC. If the LLC has at least one corporate member, they are not exempt from providing positive notification opportunities to the tenant. So if the LLC has just individuals and members, they're entitled to that. If somebody is exempt at this moment in time, we don't have to provide the exemption notice. However, when the residential month-to-month lease agreement does have the exemption notice, so please be sure that your clients do check that box. So there is no question whether or not they're obligated to provide the tenant with positive credit reporting opportunities. Okay. Any questions? All right. Well, thank you. Thanks for coming today.
Oh, they do a drawing for the.
Oh, yeah, the drawing. That's
And
right.
then
Does everybody turn their
any
cards in?
needs? Any new listings you guys want to plug?
Everybody turn their cards in? Dave, did you put your card in here? Sarah, did you put your card in here? Okay, they're donating their card.